Hi there, this is Doug Zanes. Thank you for tuning into my weekly show. This week, I would like to again focus on one of the chapters of the book that I've written that can be found on Amazon.com. It's called Winning Your Personal Injury Case, the Ultimate 8-Step Guide to Protect Your Health, Family, and Finances. And really, what I'm doing is I'm not going through chapter by chapter, but if you've listened to some of my previous shows in recent weeks, I'm covering most of the highlights, I guess. And again, I'd love for you to go and download my book or buy the paperback copy because I think it's helpful and informative. But if you're not able to or choose not to, and you listen to some of these podcasts, they will provide you with some of the information that the book contains that I think is helpful. This week I want to talk about, quite honestly, how you ultimately get compensated for your injury claim. Last week's show talked about your medical care and how all that works and the ins and outs of getting the medical care that you need and the mistakes that we see people make and how that impacts case value. Well, once you are done with your medical care, we find clients who really end up in one of two places. Either our clients are injured in an accident, they get the medical care that they need, and they recover completely. They're 100% better, they feel better, they no longer continue to have pain or problems because of their injury, and so they're recovered completely. That's one set of circumstances. And the second scenario that we see over and over again is a scenario where clients have basically gone through and received all the medical care that's available to them. And they've reached what the doctors call maximum medical improvement, meaning the doctors are saying, we've done all that we can do. We know that you're not 100% better. We know that you still have pain and problems, but we've done all we can do. We wish you the best of luck is really what the doctors are saying to the patient who is our client. So the two scenarios are somebody who's injured in an accident, receives their medical care and recovers completely, or clients who are injured in an accident, receive their medical care, but because of either the types of injuries they have or the extent of their injuries, they're never going to fully recover. But when we get to that place and we know that we are at at those crossroads. That's where the client is. He's in one of those two places. Now it's time to try to resolve their case, quite honestly, because that's what happens next. I mean, if you're better and you've recovered completely, it's time to try to find you a resolution to your case. If you're not better, but you've received all the medical care available, it's still time to try to find a resolution to your case. And so that's the next step. And so if you are handling your own case, how do you do that? And it can be a little bit different, quite honestly, or it is different for clients in the two different scenarios. But under either circumstance, the first thing you have to do is you have to get copies of all your medical records and bills and get them to the insurance company. That's the first thing that they're going to require, is they want all that information. And you can do that one of two ways. You can either go and collect them all. Get that, go pick your records and bills up from the hospital. Go pick your records and bills up from the ambulance company. Get a copy of your records and bills from the primary care physician you saw and every other medical provider. And so you can go collect all that information and send it off to the insurance adjuster. So that's one option. Even if you're willing to do that, even if you would prefer to do that, I can tell you in my experience what a lot of the insurance companies would prefer to do when they're dealing with individuals instead of attorneys' offices is they would prefer to have you sign a medical release and the adjuster will go order all your medical records and bills. And the reason they would prefer to do that is because I can tell you generally when individuals go and collect their own records and bills from their medical providers, typically those records and bills will be incomplete. and the adjuster won't have all the information that the adjuster needs. And so, that's why they would prefer to do them on their own. Now, the adjuster can't force you to sign a medical release, but the adjuster can refuse to make a settlement offer if the adjuster doesn't believe he or she has all of the information that they need in order to properly evaluate the case. So that's sort of the catch-22 for you as you're trying to take care of this on your own. So what are the things that you miss potentially if you're getting those records and bills on your own? One is on the records, medical records side, is you're simply missing complete records. Meaning, you went to the hospital because you had gone to the emergency room at the hospital, and you go to the records clerk within the hospital and say, hey, I'd like a copy of my medical records for the visit on this date. And they get you a copy of the medical records, but they didn't give you a complete copy. That includes everything. That includes the nursing notes. That includes the doctor's notes as opposed to simply the narrative. And so if you're getting your own records, you need to make sure you are getting every piece of paper that the hospital generated for your visit, or that the doctor generated for your visit, which includes notes by everybody. If you had a surgery, for example, and you are getting your records and bills together, you have to keep in mind that the anesthesiologist may have a completely different set of records, their own bills, that you will not get if you just get your records and bills from the surgeon's office. A lot of these, when you look at, for example, a surgical situation that includes a surgeon, an assistant surgeon, nurses, an anesthesiologist, they're using either an outpatient surgical facility, or they're using a hospital surgery room. Every piece will have its own bill and its own record. And you've got to get them all in order for the adjuster to have all the complete information. So that's the biggest challenge on the record side. On the bill side, the biggest challenge is getting a complete bill. The adjuster doesn't want an invoice. The adjuster wants the actual bill by the medical provider that includes the insurance coding. That, for example, a health insurance carrier would use, the coding that they would use in order to look at when you see a dollar amount. For example, there will be a code, and then it'll say, let's say, $852, and that code tells the insurance company what the actual service was that the facility or the doctor charged $852 for. Was it something with your shoulder? Was it something with your elbow? All of that is included in the code. The adjuster wants that code on every bill. Not always easy to obtain, but that's what you'll generally have to get. So if you sign a medical release and give it to the insurance carrier or give it to the adjuster, they will go and get all of that information in the complete form that they want. So that's a plus. You've got to sign the release, which makes people uncomfortable, but the plus is they go and get it. Now, one of the downsides or the minuses to signing the release is now you don't control how long it takes to get those records and bills. So you call the adjuster to check in, let's say a month after you're done treating and you've signed the release, and you say, hey, Mr. Adjuster, have you gotten all my records and bills yet? Do you have them in, and have you been able to evaluate my claim yet? And the adjuster may say, no, I'm still waiting. Well, you get a little further down the road and you have that conversation 2 or 3 times, and you're 2 or 3 or 4 months later, that starts to become a problem, because you're just waiting and waiting, and the adjuster really is controlling how long this is taking. And you don't know if they've gotten the records or bills yet. I mean, you don't know. You just know that they're telling you they don't have them. But, you don't know if they're being truthful. That's a problem. So if you go and collect all of this, which is what we do in every single case. We don't let the insurance company go and get the records and the bills. We go and get them. If you go and get them, you control that time frame, how long that takes, because you're doing all the work. And if you've got them and sent them off. And you can follow up with the adjuster and call them up and say, hey, did you receive record X and bill X from this provider? I faxed it to you yesterday. And if they say no, you can resend it until you know that they get it. And so that is, that's a big part of all of this. Is if you do it, you control the time frame. Why is the time frame important? Well, the reason the time frame is important is because it can become an issue in relation to your 2-year statute of limitations, or your 1-year statute of limitations, or whatever statute of limitations you have in whatever state you're in. That's sort of the key. And certainly if your claim involves a government entity and you have a shorter statute of limitation, in your state, then that can be an issue, because the longer it takes the adjuster to get your records and bills and to evaluate your claim, the closer you get to that statute of limitations running. So I'm going to use Arizona for an example. In Arizona, for a normal negligence case that does not involve a government entity, we have a 2-year statute of limitations. So if we have a client under that scenario, and keep in mind, there are scenarios, even in Arizona, where our statute of limitations is shorter. So I don't want you to take that 2 years, if you're listening to this, and determine, hey, that's how much time I have. No, I mean, what you need to do is be sure and talk to an attorney about your particular case, whether you're in Arizona or somewhere else, if you want to know definitely what your statute of limitations is. So I'm going to say that's, I guess, a disclaimer for me to keep somebody from coming back saying, hey, I listened to Doug's show, and he told me we have a 2-year statute of limitations, and we don't, and now my claim's gone. You got to check with an attorney in your state who specifically looks at the facts of your case, who can tell you what your statute of limitations is. But I'm going to take that general idea of a 2-year statute of limitations in Arizona. Well, if you're handling your own claim and your accident happened 6 months ago, so you still have a year and a half, that gives you a lot of time for the adjuster to get those records and bills together, evaluate your case, and try to get it done. Now, if your accident happened a year and a half ago, so you're within 6 months of your statute of limitations running, I can tell you you've got a real problem if you're handling your own case. Even if you're going to go and collect all those records and bills and get them to the adjuster, once you hit that point, the problem you're going to have is you, in my opinion, by handling your own case, have lost your leverage with the insurance company. Your leverage is your ability to sue. So if they make a bad offer, if they make a lowball offer, what you as a claimant, the only thing you can do about it is sue. Go sue the guy that hit you. Go sue their insured who hurt you and move the case forward in litigation in the court system. So if you're handling the case on your own, the insurance carrier, the adjuster, is going to quite honestly assume that you're not going to sue them unless you hire an attorney, that you're probably not going to sue them on your own. And even if you do, he doesn't care, because he knows he's got a whole army of attorneys that their insurance company uses who are going to come and fight you, who know what they're doing, who have done thousands of these cases, and you're handling your own case for the very first time and you're not an attorney. That's your leverage. So when you handle it on your own, you need to be aware of the fact that you have a leverage problem. It doesn't. I'm not saying you can't do it on your own and that people haven't done or don't handle their cases on their own successfully. I'm just telling you that you do have that leverage problem. Whether or not it actually creates a problem in your case, only time will tell as the case plays out. But the closer you get to that statute of limitations running, so you get to the year and a half mark, you get within 6 months, let's say it that way, within 6 months of your statute of limitations running, and now the adjuster's simply evaluating your case to make an offer. What I see adjusters do over and over again with people who are representing themselves is they drag that out. They say to the person, oh, I'm still evaluating your claim. I don't have an offer yet. And so your 6 months turns into 5 until the statute runs. That turns into 4, and you get to about the 3 or 2 month mark. So you've got about 3 months until the statute of limitations runs. And then the adjuster gives you a lowball offer. And now you're stuck. And that's why the adjusters played it that way. I don't want to make it sound like it's a game, because it's not, but that's why the adjusters played it that way. Because he knows now you're right up against the statute of limitations. And when you come and talk to an attorney like me, or an attorney within my firm. We're going to look at your case, and although we're going to want to help you, we probably won't take your case, because our policy is, and most attorneys I know have the same policy, if we have a potential client come to us and the statute of limitations is that close to running, we will not take that case. We don't. Because what happens is, if we take that case, we have to file that lawsuit. Now, the day we take that case, we've got to file our lawsuit. With very little information about the case, with none of the medical records or bills to properly evaluate, we've got to take it and we have to sue today. And so we start to put money into the case, we get the case into litigation, into the court system, and we have found in our experience, when we get 3 or 4 months down the road, now we've really been able to evaluate the case, we realize the case has a number of problems and should not be in litigation, and it's a case we normally wouldn't sue on. But we're stuck in the case. And so to protect ourselves, the attorneys in the firm, the firm in general, our policy is, if we get within 18 months of the statute, or within 6 months of the statute of limitations running, we generally will not come in on a case and sign it up and take the case. That's our standard policy. And so that's the challenge that you run into, is if you can't settle your case and you have to hire an attorney to sue and you're that close to the statute of limitations running, you may not be able to find an attorney. And if you can't find an attorney, then you're backed into a corner, because you either have to settle for the lowball offer, or the statute runs and you get nothing. So you're stuck. That's what you need to be really aware of. But let's say that's not a problem, and you get your medical records and bills off to the adjuster. They evaluate your case. What's going to happen is you just want to stay on top of them. You want to call them up and say, hey, Mr. Adjuster, have you evaluated my case yet? At some point they say yes, and my initial offer is X. Then the question becomes, is that a fair and reasonable offer? And I can't answer that question for you in this show this week, because the value of a case varies greatly. I mean, widely. I do know lots of people have kind of gone through, and I don't know where this comes from, but this idea that your case is worth 3 times your medical bills. So let's say you got into a normal everyday accident, you've got $6,000 total medical bills, $1,000 at the emergency room, a couple visits to your doctor, to your primary care physician, some physical therapy. $6,000, they ought to pay me $18,000. Your case may or may not be worth $18,000. Depends on a lot of things. Quite honestly, the overall impact the injuries had on your day-to-day life. Do you have wage loss or lost wages because of your injury? All of those things. Maybe your case is worth $18,000. Maybe it's worth more. Maybe it's only worth $10,000. It's just hard to tell. And again, that's a kind of a disadvantage that you as an individual have handling your own case. And I can tell you, some attorneys have that same disadvantage. I know lots of attorneys who don't do handle personal injury cases full time. I mean, they'll take your case if you come in as a potential client, because they think incorrectly that personal injury cases are easy money, but they don't have the experience to, quite honestly, know what case value is. And that's really where experience comes into play. We've handled thousands and thousands of these cases over the years. And we've seen, quite frankly, just about every scenario I can imagine play out. And we know how those cases have worked out, whether we've sued on them and had jury trials, whether we've arbitrated them, whether we've settled, and not only how that particular fact pattern or case worked out 5 years ago, but how it worked out last month. That's where we figure case value out. And so without that sort of knowledge base, you're at kind of a disadvantage, but what you have to do is just kind of negotiate it out. And what you're trying to do is get to a place where you think the settlement is a fair settlement. And I can tell you it does happen. I mean, quite honestly, have over the years taken lots and lots of calls from not really potential clients, but people who have been handling their own case, and I've always taken those calls. and they've kind of run through their fact scenario, their pattern, the fact pattern, what their medical treatment was, what their total bills are, and I've said, okay, Doug, and so given all of that, here's the maximum money the insurance company will pay me. This is what the adjuster has said, and they give me that number. I can tell you, in my experience, probably about 1 out of 10 times I've said, that's a pretty good number. Yeah, you could hire me, and your case value is a little bit higher, so I can go and get you an additional $4,000 or $5,000. But then after paying me, you're in the exact same place you would be if you just settled your case today for what's on the table. So the advice is just wrap your case up. So 1 out of 10 times, the person is actually getting a fair shake from the insurance company. The other 9 out of 10 times, in my experience, through having those conversations, my response has been, gee, you are really getting the short end of the stick. And yeah, we can get you significantly more money than what they're offering you, and you'll walk away with more in your pocket even after paying us our fee. So I can tell you it does happen. There are plenty of people who handle their own cases and are able to get as much money in their pocket as they would if they were to hire a good personal injury attorney. Having said that, for every one, in my experience, every one person who ends up in that situation, there are 9 others who end up getting the short end of the stick. So that's something to certainly keep in mind as you're handling your own case and trying to find a fair resolution to it. And you kind of run into that same problem if you have an attorney who doesn't litigate cases. And there are firms, personal injury firms, that only handle pre-litigation cases. And so you kind of end up in a place, if your attorney doesn't generally litigate cases, where if you're not able to settle it, now you have the challenge of finding a new attorney who hasn't been part of the case for, let's say, a year to then sue on your behalf. So those are basically the ins and outs that I think are helpful. I think it's good information to know if you're handling your own case. I don't, like I said, I don't think, I've never had a problem with people handling their own cases. And we as a firm, meaning me, our attorneys within the firm, have always been willing to talk to people who call in with questions about their cases. And the hope is, even if they're not hiring us, by providing some good, solid information, it helps them find a good resolution to their case that they're happy with. So that's about it. So if you have any questions kind of that revolve around today's topic or what I've discussed, feel free to send me an email. You can email me at dzanes, Z-A-N-E-S, at zaneslaw.com. And, I'd be happy to give you my thoughts and my input.